Defender. And Dawn, if you could introduce yourself and your colleagues and make whatever presentation you like. And I should note that Budget and Chair Finance Chair Bill Pridemore is with us and has been with us throughout these hearings. So
good afternoon.
Right ahead, Dawn.
Thank you. Good afternoon. To my right is Jerry Manning, our Deputy Public Defender, and to my left is Annette Crutchfield, our Administrative Services Manager. I am Dawn Diener. I'm the Public Defender here in Nashville. I want to start, as I typically do, by thanking the staff at the Public Defender's Office. They are the most committed and dedicated group of public servants that I know. Lawyers, investigators, social workers, secretaries, support staff, they all do a great job, and you are getting your money's worth out of them. So, fiscal 2014, we saw a lot of accomplishments. We've continued our system-wide representation of individual defendants. We handled somewhere in the vicinity of 29,000 cases in fiscal 14. That is a bit of an increase over years past, and where we're seeing the biggest increase is in post-disposition matters. So situations in which people are encountering negative consequences as a result of their conviction and need help post-disposition. That can include suspended sentence motions. It can include probation violations. It can include issues related to suspension of their driver's license for failure to pay court costs. So we've seen a huge increase, particularly over the last 2 years, in those numbers. And I'll talk a little bit more about how that's presenting some challenges for us as well. We added a part-time immigration specialist this year to meet our obligation to provide clients who are not citizens, either they're here legally, many of them, but provide them with advice related to how their criminal case could impact their ability to remain in the United States. And that is going well and has been successful. And we saw some success in our juvenile court program. We have a kids' rights program that provides educational advocacy. And that program has had some real accomplishments this year working with MMPS to get some agreements about early identification of kids with special needs to make sure they're getting the kinds of educational services that they need to be successful in school and stay out of the juvenile justice system, hopefully. Some of our other accomplishments this year is that we have moved more towards a system of providing what we call vertical representation, and what that really means is that the same lawyer represents you from the beginning of the case to the end of the case. And we have, for the first time, implemented some initial workload controls. And the reason for that is that we are still at our office handling far more cases than we should be handling under the performance standards that exist. That can be a complicated issue. The handouts that I've given to you today are really the ABA principles that talk about what ethical representation means in public defense work. 2 of the 10 principles of a good public defense system are vertical representation, consistent lawyer from beginning to end of case, and making sure that public defenders have control over their workload so that they can provide effective representation to every client. We are working to establish those as the priorities for our office, and that can mean that we have to decline to take additional cases sometimes. So this is the first time that we've done that. I think it is helping the office. It is helping the clients who we serve. And I think that we've been fortunate to have cooperation from the courts as we have implemented that. So the challenges that we face are, particularly in this arena, what's the right number of cases for us to take? How do we know what's too many? And I think historically the Public Defender's Office has really struggled to be able to identify and define what's the right number of cases. As Mayor Dean knows, back in the late 90s, Tennessee did a statewide time study of public defenders that produced some results that are now 20 years old and have frankly been a little bit controversial since they were released. One thing that we have set out to do and are in the process of doing right now is a new time study, call it Time Study 2.0, based upon some Models that have been used elsewhere in the country, Missouri, for instance, and Texas, have just completed these studies. They are data-driven, evidence-based, where essentially every employee at the public defender's office diligently and rigorously tracks their time. This has not been a very popular plan in the office, but I think it is the key to helping us be accountable and to be able to document exactly how hard we are working and the amount of time that it takes to properly represent somebody on different levels of cases. We've been fortunate to have the American Bar Association and the National Association of Criminal Defense Lawyers to come in and give us technical assistance with this. There was a competition to do that, and we were one of 2 jurisdictions selected across the country to have that assistance. And we also expect to have pro bono services of an accounting firm here in Nashville to help us analyze the data that we get from the time study and come up with evidence-based, data-supported workload standards for our office so we can answer the question reliably, how many cases is too many cases for us? Our other challenge has been, as I mentioned, the drastic increase that we have seen, particularly in our general sessions staff, with post-disposition matters. Traffic at our front desk has increased quite a bit in the last 2 years. And that is the reason that some of our prioritized budget improvement requests involve support staff for our general sessions team. We're seeking a professional specialist, someone who can provide administrative support for the 14 or 15 lawyers who we have in general sessions court. It might surprise you to know that right now they don't have any secretary for any of those lawyers. And so many of those lawyers are doing administrative tasks that could better be done by someone who is in the office and there instead of in court. And so we're asking for a professional specialist to support those lawyers and provide some more consistent supervision to the other intake specialists who work in our front lobby area. We're also asking for another intake specialist. Our traffic at the front desk these days are handling probably 100 to 120 people walking in every day who need to be qualified for services. That's a lot of people. In addition, our phone needs to be answered, and we average about 500 phone calls a day to our main line. And so right now we have 3 people who are doing all of that work, handling the walk-ins, handling the phones, and basically serving as triage, for lack of a better word, in our front desk area. If anybody calls in sick during lunch hours, any time that there is a stress on that point in our office, we have to pull someone off of a job somewhere else to be there. And so we think we've reached the point where we can justify an additional position at the front desk. JIS recently helped us analyze some of our processes there to see what we're doing and if we can do it more efficiently. And the feedback I immediately got was, wow, they never stop. And in fact, sometimes to the point that it seems to interrupt the intake process to have to answer phones, et cetera, and so it can take longer. So we're asking for those support positions. The other position that we're asking for is a program specialist who really is someone who can help us develop a communication strategy and better educate the public about what our office is doing, why our office is important, how we improve public safety, and how we can help individuals who are encountering the court system who we believe need help and don't need to go there without a lawyer. I think as time has passed, a lot of metro agencies have implemented these types of positions to deal with public communication, and that's one of the positions that we are seeking this year. We also do not have an investigator in our juvenile division, and it's become important for us to have one there. I think you may know the Department of Justice is in Memphis and sort of analyzing what standards need to accompany juvenile court representation of kids charged with delinquent offenses. And investigation is just as important in the juvenile court context as it is in the adult system. So we are seeking that. And I think the last challenge that I spoke of last year and will speak again this year and am eternally optimistic about is our attorney salaries. Last year, this time, I don't think the pay plan study had been released quite yet. It came out subsequent to the budget hearing and supported what I expected it to, which was that our attorneys are significantly undercompensated in the market, given the market. So the study looked at the salaries for attorneys at Metro Legal, who are paid on a higher pay scale than our attorneys at the Public Defender's Office. And so I think we're even more out of whack, for use a term of art, than the attorneys who were studied. We are optimistic that the steps this administration took last year to try to address some of those under-market positions, and we were one of them, was a terrific first step towards fixing that. But we believe there's room to improve and more that needs to be done to get our attorneys back to at least market competitiveness. So I'm hopeful that the recommendations that will be coming to the Civil Service Commission in the near future will address that and that will be funded. With that, our 3% reduction is the Guardian Ad Litem program. As the mayor is well aware, it's a program you started. When we have to cut services, generally the brunt of that falls to the state. The remedy when the public defender's office can't take a case is that we ask the court to appoint a private attorney who is paid for by the state budget.
Do they get paid?
Do the private attorneys get paid?
Right.
As far as I know, they get paid.
But you haven't heard any complaints that the indigent fund that is used to pay private attorneys, is that flush? I mean, people are actually getting paid?
Flush, I would say probably not. I do believe people are getting paid. There have been years, certainly, where that fund runs out of money at the end of towards the end of the fiscal year, and lawyers stop getting paid until July 1 comes. So I have not heard anything about where they sit this year. And we would eliminate our travel and training budget, which was restored a couple of years ago when we got some added state funding. So those would be how we would deal with the reductions.
Okay. What, you say when you reach a certain point, you decline to take cases. You know how many cases you haven't taken?
I don't know that number. I can get it for you. The only place for now that we have really implemented workload controls are on the jail dockets, where the influx of cases all at one time is sufficiently high. So in terms of criminal court cases, in terms of bond cases, we had a brief period of time with the domestic violence docket where we were kind of really drowning. But the workload controls we've implemented have to sort of put a soft cap on the number of cases we take on each of the jail review dockets every day. And generally speaking, Mondays are busy days, but other days of the week, we're not workload conflicting off anything.
Mondays because of the weekend build up on the jail docket?
Yes.
What, you heard you were here for the district attorney's hearing, and you heard me reference the information they gave us about new cases being initiated, juvenile petitions going down, transfer cases going down, criminal court cases flat, general sessions relatively flat. How has that impacted your workload?
Well, I think our number of cases handled this year is actually up, and I think that is in large part because of the post-dispositional matters that we're dealing with.
Are you being asked to handle post-dispositional matters that private attorneys had handled initially?
Yes. Ms. Manning gets the brunt of those requests, and that's a significant problem, frankly, in Nashville.
I recall that issue.
Yeah.
But is there anything the courts can do in terms of having the attorneys who initially took those cases and were compensated for those cases handle those cases?
I think they can, and certainly each judge seems to sort of have their own way of how they want to deal with that, and Ms. Manning knows.
Sounds like they want to give them the Jerry.
I think sometimes that's probably easier for them, but as we have decided that the direction we need to go is start to limit workload, we sort of feel compelled also to not be taking on a lot of other case responsibilities when we didn't handle the case originally. And
Right.
so we would like to see the private attorneys who were originally appointed, reappointed to
Well,
handle.
yeah, it would seem to me that, we're in an environment where at some level, caseload numbers, or not caseload numbers, but cases being generated into the system, new charges and things, so the system as a whole are flat or going down. And you've mentioned the ABA's concern about vertical representation, and that if you're getting inundated with cases that are really private attorneys' cases, that would seem to contradict what the ABA is suggesting, and you're put in a position of sort of helping that happen, which would seem to me that if there's a way to reduce the caseload and manage it, would be to bring this material to the attention of the general sessions judges and bring your budgetary concerns to them and say, something's got to give.
Right. And it's not just general sessions, it's criminal court cases as well.
I mean, I understand what the judges would say, for convenience, you're there, you're going to do it, and it's going to happen.
Right.
And which is probably what's driving it.
Right. And we have certainly talked to them about our switch to vertical representation and workload controls when the docket system changed in September. That was a large part of the discussion that our office had with the general sessions judges about what is a workload conflict and why are we all of a sudden going to be declaring these workload conflicts. I think we've had some success in getting the judges to understand that, and to certainly they have honored it and allowed us to do that. I think, again, the post-dispositional matters are, a lot of those individuals, also keep in mind, were pro se at the time of the pleas. There is a huge number of cases that are handled in general sessions court without any lawyer at all. And frankly, in general sessions court, that's the number. Those are the cases that tend to wind up with somebody walking into our office because they didn't have a lawyer on the front end who was telling them what all of the consequences were going to be when they accepted that plea.
And those are bond docket cases?
Bond dockets, citation dockets, yeah.
Okay. Of the things you've requested, and I'm sure they're all very good things,
They are.
what would be your number one priority?
Our number one priority is the professional specialist in general sessions court. They are drowning there. They're spending, our lawyers are there until 7, 8 o'clock at night getting dockets ready and doing a lot of things that a secretary or an administrative person could help them do. And I think the administrative professional specialist could also be someone to fill in at the front desk, be somebody who's down there supervising things related to how intake is going. So I think that's our first priority.
Okay. Rich? Greg, you got any insightful questions?
Good, thanks.
Well, Dawn and Jerry, thank you all for what you do, and thank everybody in your staff for all the hard work. I believe I understand what you do, and I know it's important, and we appreciate y'all, and we'll do the best we can.
Thank you. Appreciate it.